Thank you very much. It is for me a great pleasure to be here again. Thank you, Bob, for inviting me again to take the floor in this forum. What I would like to do here today is to give you just a very quick picture about how human rights cases can lead to mass claim litigations before the European Court of Human Rights, which is our human rights court based in Strasbourg. Let me start saying that one actually of the major development in the recent years in the European human rights system has been the adoption by the European Court of Human Rights of a new technique for dealing with mass human rights claims brought under the European Convention on Human Rights. And among these techniques, a particular emphasis has been placed on the so-called pilot judgment procedure, which is basically a mechanism for aggregate litigation of human rights claims, which has some similarities with class actions, and which was established by the case law of the European Court in order to improve the capacity of the court to deal with a violation, human rights violation affecting a large number of individuals. And I think that the recent increase in mass human rights cases before the European Court of Human Rights opens the gate to new avenues of and opportunities of transnational cooperation among European and non-European legal professionals. It is indeed conceivable that in the near future the handling of such cases involving hundreds and even thousands of claimants will require the joint action of several law firms working in different countries, and even of well-experienced mediators from other countries in the settlement proceedings and the settlement phase, which can follow or even precede the adoption of a pilot judgment by the court. One may just think about a recent case against Poland where the European Court issued a pilot judgment concerning rent control regulation, and this pilot judgment virtually affected over 100,000 landlords in Poland, which were then entitled to claim compensation. Now, I would just very briefly, I would like to make something clear for those of you who are not very familiar with the case law of the European Court of Human Rights, and that is that, obviously the European Convention on Human Rights is devised to vindicate human rights against states. But there are many instances in which states may be held accountable for the conduct of private individuals or entities through the diaphragm of the so-called positive obligation. So the states are not only required to refrain from committing human rights violations, but that they are also required to adopt positive measures to prevent or to react to violations committed by private individuals. And this so-called horizontal approach to human rights obligation, which has developed very much in the latest years, has a particular implication for mass claims human rights litigation, because it is usually with regard to positive obligation that you can have mass claims, for instance, concerning environmental hazards, smoke damages, toxic exposure, personal injuries caused by defective products, etc. Now, mass claims brought before the Strasbourg Court usually fall within three main categories of cases. The first one arises when the alleged wrongdoing of the state affects simultaneously a large number of individuals who suffer more or less a prejudice of the same nature and degree. And this is the case where an isolated act or omission leads to multiple identified victims who are all entitled to vindicate their rights individually or collectively against the state. For instance, in this respect, a couple of years ago, we have been involved in proceedings before the European Court of Human Rights where over 400 hemophiliacs they claimed a breach of the right to a reasonable time in relation to a civil proceedings pending in Italy, and we obtained a compensation of over 12 million euros globally before the European Court of Human Rights. More recently, we filed another complaint concerning the exclusion of certain hemophiliacs and other persons affected by thalassemia from the compensation schemes which were adopted by the Italian states in order to compensate damages suffered due to defective blood products. And currently we are exploring possible avenues to challenge before the Strasbourg court the failure by the Italian state to adopt adequate preventive measures in relation to death and injuries which took place after the earthquake in Abruzzo last April, and also recent event in Sicily, the mudslide, which you might have heard of. The second situation arises when the alleged violation of the European Convention, no matter if it is raised in the first place by a single claimant, turns out to be the consequence of a defective legal provision or administrative practice, which indicates that there is a structural systemic problem in the legal system of the state, and which is likely to affect in the future a large number of individuals. So in this kind of situation, you have an undetermined number of potential victims who will be able to successfully bring their claim to the Strasbourg court simply by referring to the judgment, the pilot judgment, because this is the kind of situation in which the court has resorted to pilot judgment procedure. So you merely refer to a judgment, and what is all about before the court is to determine the amount of compensation you are entitled to. And we have been involved in these kind of situations. I've been personally following a case against Slovenia which concerned very complicated issues of citizenship. Thousands of people lost their citizenship after the independence in 1994, and they were denied any legal status and any legal rights in Slovenia. And now we brought a claim on behalf of 12 people, but this claim is, if it will be accepted by the European Court, will lead to a pilot judgment potentially affecting around 10,000 people. Now, the third and last situation, which is to some extent a subcategory of the second one, concerns those instances where the violation of the Convention is the result of an endemic structural breakdown, usually due to lack of sufficient resources or inefficient organization. And in this respect, I will just mention a recent case. Usually we're talking about poor prison conditions, or about length of proceedings, or about non-execution of judgments, which are very frequent in Eastern countries, but sometimes they also come up in Western countries. We recently had in Italy a judgment concerning prison conditions in one of the major detention facilities in Rome, and this judgment concerning one single claimant actually found a breach of prohibition of inhuman treatment because of the overcrowding of the cells in that prison. And the day after, there were lawyers and NGOs working in order to bring like a collective complaint on behalf of the whole population of the prison before the court in order to get compensation for the same identical violation. Now, I will just close saying that the pilot judgment procedure, it is one of the, as I said, one of the most important developments in the practice of human rights litigation in Europe. Someone has referred to the pilot judgment as a new form of European class action, because actually it has some similarities. Basically, in the pilot judgment, the European Court is dealing with a class of people, and it's identifying a structural problem which needs to be remedied at the domestic level. Then all people falling within the class, they will be entitled to claim compensation either before the court on the basis of the pilot judgment, or most likely before domestic courts, which are then under a duty to afford an adequate compensation. Now, be as it may, I think that this new form of large-scale litigation before the Strasbourg Court should be carefully looked at by European lawyers and also by non-European lawyers, because it could prove to be indeed, in certain cases at least, the last resort in order for victims of human rights abuses to obtain a fair compensation. Thank you very much.
Thank you very much, Andrea.